Welcome to our guest docket. Today, Mike and I are going to interview our guest attorney, Isaac Heintz. Isaac, why don't you do us a favor and give us a little background about where you're from, where you went to school, and what you did before you became an estate planning attorney.
Okay. I was born and raised in Cincinnati. My father was in the symphony for over 25 years. We lived in the Clifton area. I currently live in Northside, and I'm involved with the Northside Business Association. I started practicing law around 2001. My graduate and undergraduate are both at the University of Cincinnati. Before I was an attorney, I was actually a social worker, and the last job I had was at Talbert House working with the SAMI population, which was substance abuse, mental illness. There's a lot of intertwinement with the legal system with working with those clients. I would say that my first thought when I was going to practice law was not necessarily doing estate planning. I think that focus came, I went downtown to work at Rennings Fry for a period of time, and that was pretty much all I did down there for that period of time, and it just kept growing from there. And I have a strong background in real estate. I was a title examiner while I went to school, so it kind of fit in because you did a lot of probate review and document review in connection with that.
Why don't you take a moment and describe for our viewers, what exactly is the estate planning process and what are the different vehicles that can be used to do planning?
Okay. The first step that I would say in the estate planning process is to start to understand who are the participants within your estate plan. Who are the individuals you want to entrust to take care of the actions that you need to have happen. These can be individuals that you're going to appoint as your executor. They can be the trustees of your trust if you're going to have a revocable trust or irrevocable trust. The people that are going to make decisions on your behalf when you're unable to, if you have a power of attorney or healthcare power of attorney. Also think about your assets and what assets you have to deal with. A lot of assets don't necessarily transfer by will or are going to go into your trust. Anymore, a large portion of a person's estate is typically their retirement account or something like that. So you have to think about who am I going to designate as the beneficiary of my retirement accounts, your IRAs, your 401ks, etc. Also, get together addresses, phone numbers, and all that type of thing. That's the type of information you want to have before you go to your attorney so that you have an idea of where you're going to start.
And then from there, we had talked about wills, we had talked about trusts. Are those the only vehicles that are used in estate planning? And describe kind of for our viewers what those are too.
Right. There are multiple vehicles for estate planning depending on what you're trying to do. For high net worth individuals, there's a lot of different pieces of the puzzle that come into play. There's things like the irrevocable life insurance trust, which can create a fund to borrow or to buy assets from your estate to help pay estate taxes if that's going to be implicated. There's items like family limited partnerships where you can control business assets while still giving gifts to your children of an interest in the entities during your life. Trusts can be revocable, irrevocable, depending on what you're trying to do. They can be defective so that all the income taxes to you, or they can be isolated where they're going to pay their own income taxes and do their own thing. Wills are basically the vehicle that decides how your assets are going to be transferred through your probate estate. And the probate estate is the assets that are in your individual name that do not transfer by contract or otherwise.
Now, when you talk about contract, you're talking about, for instance, insurance policies?
Exactly. Insurance policies, transfer on death designations on your bank accounts, joint survivorship, that's another type of contract or relationship that you can have that can avoid probate but have your assets transfer outside of probate.
Now, when we talk about probate, a lot of people know that there is a probate court. Is it costly to get involved with probate court?
I tell my clients that the best probate estate is no probate estate. But that being said, probate court is not as bad as some people make it out to be. It does add cost, it adds delay, and it does disclose the information as far as your assets and stuff that go through your probate estate to the public. For instance, if you pass away in Hamilton County and you wanted to find out and you were nosy about your neighbor, you could look them up on their online site and get a complete list of all the assets that went through probate and also figure out who the executor were, who the beneficiaries were, and stuff like that. So it's not, one thing it is not a private process.
And when we talk about the probate process, I know that there is testate succession and intestate succession, correct? Can you kind of explain that for our viewers?
Testate succession, what you're talking about is if you die testate, you die with a will, and the will decides how your assets are going to go. If you die without a will, then you die intestate. You die without a will. And if you die without a will, your assets are going to transfer by the statute of descents and distributions. Generally, if you're married, it's going to go to your spouse a majority of the time, depending on how much you have. If you have children outside of that marriage, then your other children also will get a share of that. If your spouse is not there, then it's going to go to your kids or their kids. And if they're not there, then it's going to go up to your parents and then back down to your brothers and on and on.
You know, we've seen some well-known figures that don't have proper wills, proper trusts, or they don't have those at all. Why does that happen?
I think a lot of it is people don't like to think about passing away and trying to plan for the future. You know, I can't speak as to the individuals, but I have seen a lot of clients come into my office who you would think would have the estate planning done, and they don't have it. And all I can say is they're doing it now, and that's a positive step.
When and how do you pay the taxes related to estates?
Well, keep in mind that at this point in Ohio, unless you have an estate in excess of $5.4 million combined with your spouse, you don't really have to worry about estate taxes at all. So that's for the average person. I think estate taxes are no longer an issue right now. Now, of course, they could change the laws. Who knows? But
so if you're under $5.4 million, let's say you have a gentleman with a $750,000 estate and he passes away, would he be looking at costs in probate or for taxes?
There would be no estate taxes on an estate that size.
When you are getting information together for a will, just a regular person, unlike some of the people that we talked about earlier, should you have relatives that will be the guardians of your children or the trustees, and can you have people from out of state, or what do you recommend in a situation like that?
My recommendation is use the people who you feel are going to do what you want to have happen. So if that's your friends, if that's your family, that's wonderful. But it's that person that you trust to see your final wishes through.
Now, we've also talked about trust. Can you define for our audience the basics of a trust, how it works in estates? Right.
I think what we're typically talking about when we're talking about estate planning is a revocable written trust. So an agreement where a trustor or grantor establishes a trust and appoints a trustee to deal with the assets that are subject to the trust. The trust should determine who the trustee is and how the assets are going to be distributed. With a trust, you can be very creative and you can control a lot of what's going to happen with the assets in the trust. Especially with young children, even if you're of modest means, a lot of times a trust will be an important vehicle that you can use to help preserve the assets for a period of time. Obviously, if you have a young child that's 19, you probably don't want them to get a couple $100,000 if both their parents just passed away.
Power of attorneys. You have the durable power of attorney for health care and for finances. Is that correct?
That is correct.
When do they take effect?
Well, it depends. That's a good question. There's two different ways to have it done. With the healthcare power of attorney, the healthcare power of attorney is typically going to take effect when you're unable to make the medical decisions on your behalf. The question, though, with the financial power of attorney is whether or not you elect to have what's called a springing power of attorney or a standing or durable power of attorney. A durable power of attorney or standing power of attorney is a power of attorney that's in effect as soon as you execute it, and that individual or the individuals listed within that power of attorney are going to have the right to have whatever financial decisions are listed within that document and to make those decisions on your behalf. A springing power of attorney requires a condition precedent prior to it becoming in effect. My personal preference is a standing or durable power of attorney, and I leave it to the clients to make that decision. My concern with springing power of attorneys is coming up with a standard that's very clear that has it go into effect. I'm concerned that when you go to the doctor to ask them to write a note that you're incompetent or that you're unable to handle your financial affairs, some medical professionals, depending on what the issue is, are going to be hesitant to write that note. And then you could be back in the situation which you're trying to avoid. The option to the power of attorney is having to go to probate court and have a guardian appointed of the estate and of the person, which is what you would like to avoid by executing the power of attorney in the first place. And one key I want to point out is this is a common misconception, but powers of attorneys terminate as soon as you pass away.
Well, Isaac, thank you very much for joining us today and sharing this information. We really appreciate you being here. Please stay tuned for our resource docket next.